Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. And I'm sincere when I say empowerment lawyer because my objective on this channel is to empower you. I want to talk about discovery today and producing documents to the defense counsel off the record. I would say to you, don't give the defendant documents off the record. What do I mean by that? After the plaintiff files a lawsuit, sometimes defense counsel will ask the plaintiff for documents. Discovery hasn't begun. It's almost at the front of the lawsuit. But for some reason, defense counsel want to see plaintiff's documents that early in the lawsuit. Well, when those records are given to the defendant off the record, there is no record. And that could put the plaintiff at a disadvantage. So let's talk about why the plaintiff should not produce, disclose, or give any records to the defendant off the record. So let's get started. Before we get into the reasons why the plaintiff should not disclose their documents off the record, let's look at Federal Rule Civil Procedure 26. It is the rule that governs discovery. In a nutshell, it prescribes when and how discovery is conducted after the lawsuit is filed and after the defendant has responded to the complaint. There are 7 sections to this rule that I want to go over. Section A deals with initial disclosures. And what are we talking about here? Before either party propounds discovery during the formal process, each party is required to provide certain information and documents to the opposing side. And you'll see this when you read that section. Section B deals with the discovery scope and limits. It identifies the discovery the party can obtain and the limitations to that discovery. It addresses trial preparation material, experts and expert material, privileged material, protecting trial preparation materials. I know it looks scary and difficult, but again, once you read the section, it will make sense to you and it won't look so scary. Section C deals with protective orders. It addresses when a party may move for a protective order to secure discovery, let's say where opposing counsel does not produce the discovery upon the request. There are certain things that must be done before a protective order or a motion for protective order is filed. And of course, you want to always look at the jurisdiction rules, the local rules, in addition to federal rules. And it also addresses actions the court may take against the party the protective order is made against. Section D addresses the timing and sequence of discovery. It dictates when a party may seek discovery from any source. Section E addresses supplemental disclosures and responses. The parties are obligated to supplement their disclosures and responses. Let's say if after having disclosed or responded, the party learns that the information is incorrect or maybe incomplete, that party is obligated to correct the record. Section F addresses the conference of the parties and the planning for discovery. This is how this works. After the defendant has responded to the plaintiff's complaint, the federal rules require that the parties participate in a scheduling conference. It's called the 26F conference. At that conference, the parties will map out a discovery plan. And this will be used in managing the case for both sides. Now, let me say this. Make sure you read the local rules, because the local rules may not require that the parties participate in a 26F conference. Okay? Lastly, Section G. It addresses signing disclosures and discovery requests, responses, and objections. Each of these need to be signed. Now, let's get into the 5 reasons why the plaintiff should not give the defendant their documents off the record. The first reason is the plaintiff is not required to disclose their documents outside the Federal Rules of Civil Procedure 26 as it prescribed and as we just went over. The second reason is when the plaintiff discloses his or her documents off the record, there is no record. This could work to the plaintiff's disadvantage. It could even be fatal. Let's say that the defendant filed a motion for summary judgment. Federal Rules of Civil Procedure 56 governs motions for summary judgment, both for the party making the motion and for the party responding to the motion. And Federal Rule Civil Procedure 56 is clear that when the party making the motion or responding to the motion must cite the evidence in their brief. They must show the court where the evidence can be located. And let's say the plaintiff wants to use the document that it previously gave the defendant that is not on the record to support their position. The defendant likely would file a motion on the ground it was never formally produced to them, or it is not on the record. You see the problem this could cause? That's why the plaintiff should only produce documents to the defendant under the umbrella of the Federal Rules of Civil Procedure 26. Reason 3 really speaks to documents and information that should never be disclosed to defendant, period, because they are protected by the Federal Rules of Civil Procedure 26. And I've listed 4 here. Mental impressions. The mental impressions of the plaintiff includes documents and information that arises from the plaintiff's senses or the plaintiff's feelings. It's the plaintiff's creativity. In a nutshell, it's really like the plaintiff's intellectual property. That belongs to the plaintiff. And he or she does not have to disclose that and make that information available to the defendant. Legal theories. The legal theory that the plaintiff has advanced in the case, that belongs to the plaintiff. The plaintiff's conclusions, the plaintiff's opinions, all of these are protected by the federal rules. And unless the federal rules state otherwise, the plaintiff should not disclose them and is not required to. Reason 4 is similar to 3. The plaintiff's work product. Documents that the plaintiff prepare in anticipation of litigation generally are not subject to discovery. Now, again, you want to read the rules, the federal rules, and also the local rules. The plaintiff's work product, for example, would be making notes. Often when the defendant deposes the plaintiff, they will ask for notes, a calendar, so on and so forth. Well, generally, if these notes and calendars and other writings are made in anticipation of litigation, they are not discoverable. They are part of the plaintiff's intellectual property, absent any other rule, because they were created by the plaintiff, arising from the plaintiff's feelings, senses, thoughts, so on and so forth. So keep that in mind. Reason 5 is one that I hear about quite a bit, where after the defendant asks the plaintiff to produce documents, the plaintiff does so with the understanding that the parties will discuss settlement. Only after producing the document, settlement discussions are off the table. So you see why it's critical that the plaintiff not produce documents off the record and produce only those documents that Federal Rule 26 prescribes, and keeping in mind that there are certain documents that the plaintiff does not have to produce that are protected under the work product. Okay? I hope this has been helpful to you. Until next time, this is Advocate Lucinda, your empowerment lawyer.